At some point in your life, you've probably signed something without reading it. A phone plan, a gym membership, a terms and conditions page, maybe a lease, maybe an employment agreement. And at the time, it felt fine because everyone does it, because the document was 20 pages long, because the person behind the counter was waiting. But here's what most people don't understand. The moment you sign, the law largely stops caring whether you read it. What's in that document, all of it, is now your problem. And in some cases, what isn't even written down can be your problem too. Contracts are the backbone of almost every legal relationship in modern life. Understanding what they actually are, how they work, and where they quietly go wrong is one of the most practical things you can know. Most people think a contract means a formal document with signatures at the bottom. Legally, that's not the full picture. A contract is an agreement between two or more parties that the law will enforce. And in most legal systems, a valid contract requires three core things: an offer, an acceptance, and something of value exchanged on both sides, which lawyers call consideration. That exchange of value doesn't have to be money. It can be a service, a promise to do something, or a promise not to do something. What it can't be is completely one-sided. A promise to give someone something for absolutely nothing in return generally isn't a contract in the legal sense. It's closer to a gift, and gifts aren't enforceable the same way. Here's where it gets interesting. Contracts don't always have to be written down. Verbal agreements can be legally binding. A handshake deal, a phone conversation, even an exchange of messages. These can all form a contract if the right elements are there. The problem with verbal contracts isn't that they're invalid. It's that they're hard to prove. When a dispute arises, it becomes one person's word against another's, and courts have limited tools to resolve that. Some contracts are required by law to be in writing to be enforceable. Real estate transactions and agreements lasting longer than a year are common examples, though the rules vary by jurisdiction. But outside of those categories, the absence of a written document doesn't necessarily mean the absence of a contract. There is a legal concept that makes most people uncomfortable when they first hear it. You are generally bound by the terms of a contract you sign, even if you didn't read it. The reasoning behind this is straightforward. Courts don't want to open the door to people avoiding their obligations simply by claiming ignorance of what they agreed to. If that were a valid defense, contracts would become unenforceable almost immediately. This is why the fine print matters far more than most people treat it. Standard form contracts, the ones used by phone companies, streaming platforms, gyms, landlords, employers, and banks, are often written to heavily favor the party that drafted them. That's not an accident. They are engineered that way. The clauses buried deepest tend to be the ones with the most impact. Automatic renewal terms that lock you in for another year if you don't cancel within a specific window. Arbitration clauses that waive your right to sue in court. Limitation of liability provisions that cap what you can recover if something goes wrong. Unilateral amendment clauses that allow the company to change the terms of the agreement after you've signed. That last one deserves attention. Many modern service agreements, particularly online ones, include language stating that the company can update the terms at any time, and your continued use of the service constitutes acceptance. You may not receive any notification. You may not be asked to agree again. The terms simply change, and you're bound by them. Here's a dimension most people don't consider. A contract doesn't only contain what's written in it. In many legal systems, certain terms are implied into contracts automatically, either by law or by custom in a particular industry. These implied terms exist whether or not the parties ever discuss them, and sometimes even if the written contract tries to exclude them. A contract for services, for example, may carry an implied term that the work will be performed with reasonable skill and care. A sale of goods may carry implied warranties about quality and fitness for purpose. An employment contract may carry implied terms about notice periods or the employer's duty not to act in a way that fundamentally destroys the working relationship. This matters because people often look at a contract and think, it doesn't say anything about that, so I have no protection. That isn't always true. Depending on your jurisdiction and the nature of the agreement, the law may provide protections that exist entirely outside the written document. The flip side is also real. You may have implied obligations too. Duties of good faith, confidentiality in certain contexts, obligations to perform in ways that weren't spelled out explicitly. The written document is the starting point, not the complete picture. Signing a contract doesn't always mean you're locked in permanently. There are legal grounds that can make a contract voidable, meaning a court may allow you to walk away from it. Misrepresentation is one of the most common. If someone induced you to sign a contract by giving you false information, even if they believed it was true at the time, that may give you grounds to challenge the agreement. The key question is whether you would have signed had you known the truth. Duress is another. If you were pressured into signing under threat, not just a hard sales pitch, but actual coercion, the contract may not be fully enforceable. The threshold for what counts as legal duress is high, but it exists. Contracts can also fail if one or both parties made a serious mistake about a fundamental fact at the heart of the agreement. Not a mistake about whether you got a good deal, but a shared mistake about the very basis of what was agreed. And contracts that ask you to do something illegal are generally unenforceable on their face. A written agreement to do something the law prohibits doesn't become legitimate just because it's signed. There's also unconscionability, a doctrine used in various jurisdictions to strike down contracts that are so unreasonably one-sided or were signed under such unequal circumstances that enforcing them would be fundamentally unjust. Courts don't apply this lightly, but it has been used to void contracts in extreme cases. What won't get you out of a contract? Changing your mind, deciding the deal wasn't as good as you thought, or not having read what you signed. These are not legal remedies. They're regrets. When one party fails to perform their obligations under a contract, that's a breach. But not every breach carries the same legal weight. A material breach is one that goes to the core of the agreement, something significant enough that it effectively defeats the purpose of the contract. If you hired someone to build a website and they delivered nothing, that's a material breach. The non-breaching party is typically released from their own obligations and can pursue compensation. A minor breach is a partial or technical failure that doesn't undermine the whole agreement. The work was done, but not quite to specification. In these cases, the non-breaching party may still be owed compensation, but they can't simply treat the contract as cancelled. The standard remedy for breach of contract in most systems is damages, money intended to put you in the position you would have been in had the contract been performed. Courts are generally not in the business of ordering people to actually do what they promised, though in specific circumstances, particularly involving unique goods or property, a court can issue an order requiring performance. One important limitation: when a contract is breached against you, you generally have a duty to mitigate your losses. You can't simply sit back and let damages pile up when you had a reasonable opportunity to reduce them. Failing to mitigate can reduce what you're ultimately awarded. A contract is not just paperwork. It's a legally binding set of promises, and the law treats it that way regardless of whether you read it carefully, whether it felt fair, or whether anyone explained it to you before you signed. Most important shift in how you think about contracts isn't becoming suspicious of every agreement. It's understanding that the document in front of you represents real consequences, and that the moment you sign, the terms belong to you. Read the key clauses. Pay attention to what you're giving up, not just what you're getting. Know that some protections exist whether or not they're written down, and that some written terms can still be challenged if the circumstances are serious enough. Contracts govern almost everything in modern life. The people who understand that aren't just more legally protected. They make better decisions before the pen ever touches the paper. This video is for general educational purposes only and is not legal advice. Contract law varies by country, jurisdiction, and the specific terms of each agreement. If you're dealing with a specific legal situation, consult a qualified attorney in your area.